Okay, everyone. Welcome. Thank you for being here. Welcome to today's panel on understanding state Supreme Court elections in Wisconsin and beyond. We appreciate all of you coming out in person and welcome those of you joining us virtually. My name is Miriam Seifter. I am a law professor at the University of Wisconsin Law School and one of the faculty co-directors, along with Rob Yablon, of the State Democracy Research Initiative here at the law school. I will be your moderator today. This event is jointly hosted by the State Democracy Research Initiative and by the University of Wisconsin's Elections Research Center. We're grateful for the partnership of ERC and its director, Professor Barry Burden, who you will hear from in a bit. And we are grateful for generous sponsorship from the Wisconsin law firm Stafford Rosenbaum. To introduce our terrific panel today, I'm going to turn the floor over to Carly Gerrits, a partner at Stafford Rosenbaum. Carly?
Thank you for the introduction. Stafford Rosenbaum is a full-service law firm with both offices here in Madison and in Milwaukee. Among the firm's many practice areas is election and political law. Our election and political law team has a breadth of knowledge and practical experience that is unmatched in the state. Among other things, the team has represented dozens of individual voters and nonprofit voting advocacy groups and organizations in voting rights litigation. It's a real honor to sponsor this series and to be here today to introduce the panel. I could spend all day introducing this esteemed panel, but in an effort to save some time, I'm going to provide a very brief introduction of each of the panelists. Our first panelist is Michael Kang. Michael is a class of 1940 professor of law at Northwestern Pritzker School of Law. He received his JD from the University of Chicago Law School and his PhD in government from Harvard University. Michael is a nationally recognized expert on a number of topics, including campaign finance and judicial elections. Some of his recent work focuses on partisan gerrymandering, the influence of party and campaign finance on elected judges, and the deregulation of campaign finance after Citizens United. Of note, Michael was also appointed by President Biden to the Presidential Commission on the Supreme Court of the United States. Our second panelist is Quinn Yeargain. Quinn is an 1855 professor of law of democracy and associate professor of law at Michigan State University College of Law. Quinn received their JD from Emory University School of Law, after which they clerked on the 11th Circuit Court of Appeals. Quinn's scholarship is organized around the relationship between democracy and legal developments, and some of their research focuses on the use of democracy to expand and contract state constitutional rights and liberties, as well as institutional changes in state constitutions through amendments. Quinn is a co-author of a state constitutional law casebook that's set to be published next year, and they regularly file amicus briefs on matters related to state constitutional law. Last but not least is our final panelist, Barry Burden. Barry is a professor of political science at the University of Wisconsin-Madison and holds the Lyons Family Chair in electoral politics. He is also the founding director of the Elections Research Center. He received his PhD from Ohio State University and was a faculty member at Harvard University before coming to UW. Barry's research and teaching are based in American politics with an emphasis on electoral politics and representation. His recent research examines aspects of election administration and voter participation. He has been an expert witness in multiple court cases and legislative hearings concerning changes to election law. With that, please join me in welcoming our panelists.
Wonderful. Thank you so much, Carly. So before we begin our panel discussion, just a few more words from me. The first thing I need to do is a little bit of obligatory housekeeping with apologies. So for those of you in the room, as you may have suspected, this panel is being live streamed. Wanted to give you a heads up about that. Welcome again to our virtual attendees. This event was approved for 1.5 Wisconsin CLE credits by the Board of Bar Examiners and for 1.25 Minnesota CLE credits. We will conclude at 4:15 p.m. For those of you who are here in person seeking CLE credit, there is a sign-in sheet. Please make sure you sign in before you leave. If you are attending virtually and want CLE credit, please listen for the passcode, which I will definitely remember to give around 4:05 p.m. At the conclusion of the panel, you can watch for a Google form link, which will be in the chat box. Complete that form with the passcode, by 8 p.m. today, and you will get CLE credit. In addition, we're going to save time for Q&A at the end of the panelists' remarks. If you're here in person, you'll see an index card in front of you. Please use that to submit your question. People will come around and collect them. If you're watching online, please use Zoom's Q&A function, not the chat, but the Q&A function to submit your questions. I'm going to collect as many of them as I can and ask them of our panelists at the end. So that's the housekeeping. The second thing I want to do just briefly is provide a little bit of context for today's discussion on state Supreme Court elections in Wisconsin and beyond. Maybe we can start with Wisconsin. If you are based here in the state, you are probably hearing a lot about the state Supreme Court race in the news and in advertising. And although the advertising is constant, it often doesn't really capture what the race is about or what the stakes are. The ads are often a sort of back and forth about who is tougher on crime or more stringent in criminal sentencing, but those are questions that would very seldom come before a state Supreme Court justice. The reality is that the election matters and people care about it so much because of the very consequential work that the state Supreme Court does. The state Supreme Court is a law-declaring court. It answers difficult legal questions for the benefit of the entire state. It often only hears a few dozen cases a year, but those cases tend to be selected precisely because they raise legal questions that matter to people across the state. They set the rules for topics ranging from insurance to family law, and lately to headline-grabbing topics like abortion and redistricting. An additional reason that this particular election is getting a lot of attention is that it will determine the ideological makeup of our closely divided court, at least for some amount of time. The retirement of Justice Ann Walsh Bradley, the court's longest-serving sitting justice, leaves an open seat. And the two circuit court judges vying for that seat, Judge Susan Crawford and Judge Brad Schimmel, would be likely to move the court in different directions. Okay, so that's Wisconsin, but let's zoom out for just one more moment, because the increasing attention to judicial elections here is part of a broader pattern that's happening across the country. For a long time, state high court elections were really pretty sleepy affairs. Fairly low turnout, little fanfare. They were not covered much in law schools or talked about a whole lot in public dialogue. And really, that inattention was never very well justified because state courts, as many of you know, decide the overwhelming majority of cases in this country. As Wisconsin's late Chief Justice Shirley Abrahamson put it, the state judges are the workhorses. State courts carry the heavy burden of dispensing justice. It is the state courts that interpret the rules that people live by. So that has long been true. But recently, we've seen state courts be in the spotlight more. That's at least in part due to changes in the U.S. Supreme Court and its case law. In 2019, the U.S. Supreme Court decided a case called Rucho versus Common Cause, holding that partisan gerrymandering claims are not justiciable in the federal courts, and that has pushed much of the litigation and dialogue over redistricting and fair maps to the state courts. Similarly, the U.S. Supreme Court's 2022 decision in Dobbs versus Jackson Women's Health Organization has pushed the issue of abortion to state courts and state constitutions. So the attention to state Supreme Court races around the country has increased, as has the spending, as we will hear more about from our panelists today. And yet, even so, our collective understanding of state courts and state judicial elections has not really kept pace. So we are excited and honored that this distinguished panel is here to discuss judicial elections with us. What we hope to do today is shed more light than heat on this important upcoming event, to clarify what state Supreme Court elections are about, and to provide some broader context, both from Wisconsin's history and from around the country. So with that, enough from me. I will start by asking each of our panelists to kick us off by speaking for a few minutes on one aspect of this topic, and we'll just actually go in the order in which we're seated. So we'll start with Barry Burden talking more about judicial elections in Wisconsin, then Michael Kang on spending-related questions, and then Quinn Yeargain on what we can learn from judicial elections elsewhere in the country. Barry, all you.
All right, thanks, Miriam. I want to talk about what I think are pathologies of the Wisconsin Supreme Court election system. You're experiencing them now in the run-up to the April 1st election. So I'm going to show you some of the things that have really transformed the nature of these elections in a very short period of time, 10 to 15 years. Hopefully you can see these from over my head. First is the level of public participation in these elections. As Miriam mentioned, these were once relatively sleepy affairs. Just 10 or 15 years ago, it would not have been unusual for 20% of eligible voters to participate in a Supreme Court election. In the last Supreme Court election 2 years ago, the turnout rate was 40%. That's higher than the turnout rate in midterm elections in many states. In some cases, it approaches presidential election turnout in some states. That was for one nonpartisan seat on our state Supreme Court. There are a couple outliers here. You'll see 2011. That election essentially became a proxy for the Act 10 battle that was happening at the state capitol. The 2016 election happened on the same day as simultaneous presidential primaries. It was an open primary on the Democratic side, Republican side. So set those two aside when they were really not driven by the normal factors. It's been a steady upward climb in public interest and participation in those elections. So this is a real change, a doubling in turnout. Second is the amount of money spent on these campaigns. Just a few years ago, $1 or $2 million would have been typical from each side. The candidates and groups that are allied with them, and maybe the political parties if they were involved. There was actually 1 year when public funding was available. That was in 2011 when both of the general election candidates took the public funding. That era is over. As you probably know, the last Supreme Court election 2 years ago set a record for the most expensive judicial election in American history. No one has the exact number. It's north of $50 million between the candidates and supportive groups and political parties. This year's election, I think, will beat that. There was a story this week indicating that over $40 million just in ad buys has been reserved between now and April 1st. So it's tens of millions. We don't know the number, but we're going to be off the chart as I've created it there. And notably, more than half of the money that's now spent is not from the candidates' campaigns. It is from parties, PACs, super PACs, and dark money groups. So the majority of the money is now coming from those outside actors. Third trend that's happened is that Supreme Court elections have started to look like presidential elections in Wisconsin. In terms of turnout and money, they're close, but the voting patterns in Supreme Court elections now almost perfectly mimic how people vote in presidential elections. This is the correlation between the vote for president in each county and then those same counties' votes in the Supreme Court election. So if the two were unrelated, it would be a correlation of 0, and it actually starts there in the 1990s, but it has quickly moved upward. In the last election, I think the correlation was around 0.95. So maybe we'll beat that this year. There's not much room to go above that. 1.0 would be a perfect relationship between those two things. So even though this is still a nonpartisan election, there are no party labels on the ballot, it has effectively become a proxy war for the parties, and voters seem to know what side the candidates are on. So how did we get here? It's a road, I think, that goes back at least 15 years. A few things to note on the path that brought us here. First are some changes in election law, especially campaign funding. There were the Citizens United and other related decisions coming out of the federal court system that opened the door to super PACs and other groups that were not coordinating with the campaigns. That's in 2010. The public financing regime that was available to candidates was effectively killed by state law in 2011. So those are kind of early movements that give funders more opportunities to get involved. And then a big one was in 2015, 10 years ago, when state law was changed, partly in response to those federal court decisions, to allow unlimited amounts to be given to political parties, and then in turn, unlimited amounts to be given from the political parties to the candidates. So there are still hard money limits on what an individual can give to a candidate. That's $20,000. But a person can give $1 million to the Democratic or Republican Party, and that party can then give it onto the candidate's campaign. So it's essentially a pass-through with no limits. Third factor on the road, I think, is the rise of divided government. When Tony Evers was elected governor in 2018, Republicans retained the state legislature. Those two branches of government don't get along well. There's not much productive lawmaking happening. And so many of the hot button issues are now resolved in the courts, whether it was COVID debates or education policy or election law or just about anything else. Abortion now, Act 10 is back. All of those things are heading their way to the Supreme Court because they're not being resolved in the lawmaking bodies, as you might expect. And then I think last and sort of threaded through all of that is just the intense polarization and differences between the parties that have emerged in Wisconsin that has raised the stakes for what the court is involved in. The fact that the lawmaking branches are not resolving those things means that there's real incentive for ideological litigants and other groups to bring cases to the court, to fund them, and to be involved in them. So I don't see the road ending anytime soon. That's Wisconsin.
Thank you so much, Barry. Michael.
Okay. Thanks, Miriam, Rob, Bree, Evan, all of you guys for putting together all these great events, and it's great to be here. So I think my role here is to provide some of the national context surrounding what's going on in Wisconsin judicial campaign finance, and I think in lots of ways Wisconsin's exceptional, but in other ways it's really representative of what's happening all over the country. I think Wisconsin's exceptional for all the reasons that Barry pointed out. I think what's also worth saying is that ideological / partisan control of the Supreme Court's up for grabs. It's not up for grabs in every state, and if it was in Idaho or Montana or something like that, it might be equally partisan and ideological. You might see more money in those races, but here it really is. And what's more, I think control of the state Supreme Court here is particularly important, in part because it helps determine whether gerrymandering is going to continue to leave Republicans in charge of the state and favor Republicans, and that has national consequences that I think attracts money and attention from the parties. So I think even though Wisconsin's exceptional in certain ways, it reflects pretty well what's going on nationally in lots of other ways. But the investment happens in part because of some of these political circumstances. And obviously, as Barry pointed out, the 23 race set records for spending around $50 million. Probably this race will break those records, I imagine. And that's very much on trend for what we're seeing all over the place. Barry and Miriam both quoted Roy Schottland, the late Roy Schottland's assessment that at one point judicial elections were sleeping affairs. That's definitely not true anymore. And we've seen is it happens in different ways in different states, but spending is tracked pretty dramatically upward since the 80s and 90s. It's kind of jumped up at different times depending on some critical election or whatever's happening politically in the state. And there's lots of reasons for this. Some of them are legal, as Barry pointed out. A lot of this is just what's happening generally in American politics, which is hyper-partisanship that's driving up competition and partisanship basically at every level in every institution, and now that's kind of crept out to the judiciary. I think another factor specific to judicial elections is that ideological interest groups have realized this is a pretty good return on investment, that maybe not in Wisconsin, the state Supreme Court races are pretty expensive now, but in lots of states, the state Supreme Court race is relatively cheap. It's a bargain to invest in compared to spending on the governor's race or a Senate race. And it's easier to flip potentially the state Supreme Court than it is to flip the legislature to your side, right? And a good example of this is a case called Caperton versus Massey that some of you might have heard of. I don't have time to talk about it right now, but we can come back to it in the Q&A if people are interested. But that's a really good example of a relatively small amount of spending that had a pretty dramatic effect on political outcomes in West Virginia because not much was spent on those elections, at least initially, and they were able to flip the Supreme Court from Democratic to Republican control. My co-author Joanna Shepard and I have spent, I guess now the last 15 years studying campaign donations in state Supreme Court races and how money seems to affect judicial decisions. The effect of these contributions. And we started out looking at business contributions. And the reason we did that is not because we're particularly suspicious of businesses, but businesses spend a lot of money. Business cases are a big part of the docket. And it's pretty easy to kind of figure out what business groups kind of want in lots of these business cases. And so methodologically, it's really useful to start out there. But and what we found was that business money was pretty predictive of decisions kind of in favor of business interests, what they want in lots of different cases. It's turned out to be really robust. So we look at this in lots of different ways. We went beyond business groups. We look at political parties and their giving to judges and how judges decide kind of election contests where partisanship and partisan loyalty is really critical. We've looked at broad ideological coalitions and how money from those coalitions affect judges' decisions across a big swath of cases that we can think about ideologically. We've looked at different time periods before and after Citizens United, data from different sources, and we always find a pretty consistent, predictive, effective money on judging. This doesn't mean that money determines outcomes wholesale. That's clearly not true. Other things matter for sure. Ideology matters, partisanship increasingly matters. We find, this might surprise you, but law matters. It turns out that if you have a stronger case, you do better. And that often defeats partisanship, even in cases where partisanship is important, like these election cases. It turns out, like, if you have a strong enough cases, judge will vote against their own party because they at least kind of from one philosophy of law, they kind of have to, or they feel that they have to. But money matters too. Like, it is an important thing. We find that really consistently. And we think the Supreme Court actually acknowledges that in treating judicial campaign finance differently than it treats other types of elections and other kinds of campaign finance. One of the things that we didn't study so much, at least initially, was why the money matters. So it seems like money affects judicial decisions, but why does it affect judicial decisions? And that might seem obvious, maybe, at first blush, but there's actually at least two accounts that you can imagine. One is what we call a selection story, which is the money lines up with decisions because the donors are giving to judges or judicial candidates that favor their interests in the first place. That's why they support them. So when those candidates get elected to the bench on the strength of that money, it's no surprise that their decisions align with the money because the donors have picked the right horses, right? But there's an alternate story, which is what we call a biasing story. And the idea there would be judges in an election system, they know they have to run for re-election, and they know they need money to win re-election. And so what do they think? They think their supporters in the past are likely to be supporters in the future as long as they continue to serve those interests. And so they have some incentive to kind of bias themselves toward their supporters' interests. And so we have these two accounts. To be honest with you, when we did a lot of these studies, we weren't that interested in teasing the two apart. We thought money matters one way or the other. Money gets what it wants, and that seems worrisome by itself and interesting. But we got a lot of questions about whether there's really biasing going on, how would we know? And people seemed a lot more worried about biasing than they were about selection. And so we decided we would try to figure this out. And the methodological challenge is that if you look at the money and the decisions, you get the same pattern with either story, right? The money is going to align with the interests of the donor, and it's hard to tell which one's going on. And so what we really need to find is a set of judges who were elected in exactly the same way. They had to raise money from donors to get on the bench, but they're no longer eligible for re-election. They can't run for re-election because then we can figure out by comparing those judges with the judges who are going to run for re-election exactly what role re-election plays. And so we find this with lame duck judges in states that have mandatory retirement ages. So in those states, when the judge is re-elected or elected for the first time, if they're an older first-time candidate, they know at the beginning of that term that they're going to hit this retirement age and they won't be eligible for re-election at the end of that term, and they don't have to worry about re-election even if they wanted to run for re-election. And so when we look at these lame duck judges and we compare them with all the other judges, what we find is the effective money on the lame ducks drops off by half to 2/3. And what we think that means is re-election matters. It's a big part of the story, and that biasing is happening. Now, it doesn't get rid of, lame ducks still seem to, their contributions that they've received still are predictive of their decisions to a degree, right? A lesser degree, but still a degree. That's not surprising, because we do think that selection is happening. It makes sense that donors are giving to judges and judicial candidates who they think are going to favor their interests. So it makes sense that that's happening. But I think our data shows that re-election is a big part of the story, and that biasing is a big part of the story. So in the book, at least, and I brought the book, this is what the book looks like, what we propose is get rid of judicial re-election. That is, you can keep your judicial elections. It's probably not going to change. No state's really seriously considered getting rid of judicial elections in a while. They're actually pretty popular with the public, so we sort of concede that. But what we suggest is you can go a long way toward addressing the role of money, even with judicial elections, by giving judges one long term, but they're not eligible for re-election at the end. And that to an important degree ought to reduce the influence of money, or at least that's what our findings suggest. So I'll stop there. Thanks.
Thank you so much, Michael. Quinn?
All right. Well, thank you, Miriam and Bree and everyone else for putting together this great event. In thinking about elections that are happening in judicial spaces this year, though it's technically an off year, I'd be remiss to not mention that there's no off years when it comes to elections. That every jurisdiction, every state has elections of some kind pretty much every year. They're just typically lower profile ones. And in surveying sort of what's happened this year, what will happen this year, gives a pretty good sense as to the kinds of trends that we're seeing in judicial elections more generally. So first, Louisiana had technically a Supreme Court election earlier this year. I say technically because it was supposed to happen sometime this month, but only one candidate filed. And so there was no election on the ballot. It was canceled. Wisconsin is obviously having its election to significant fanfare. Later this year, Pennsylvania is having retention elections for 3 Democratic appointees or members of the Supreme Court, as well as open seats for both of its intermediate appellate courts, the Superior Court and the Commonwealth Court. And I'll note tomorrow, Louisiana voters are voting on 2 separate constitutional amendments that modify courts and judicial elections in some form. The first of them allows the legislature to create specialty courts. It's largely thought that that's meant to undermine New Orleans' ability to govern itself. And one of the other ones requires sooner special elections for filling judicial vacancies. And that pretty much covers, broad trends that we see in judicial elections and the relationship between things like constitutional amendments and the ballot. So first, there's a high level of engagement in partisan elections, especially in swing states. We saw this in 2024 when a number of states had partisan judicial elections. Control of the courts was on the line, and voters reacted accordingly. But we're also starting to see growing engagement in formally nonpartisan elections where the stakes are very clear, or in swing states. And this is a little bit more nuanced to some extent because the stakes aren't always clear, even in states that have courts that are sort of on the balance, are deciding these important issues, and so on. Kentucky and Montana had highly watched Supreme Court elections take place last year. Harder though to get a sense as to what the stakes were because the courts are sort of less easily sortable into liberal or conservative camps. They're a little bit more nuanced than that. There's been historically a very low level of engagement in judicial retention elections. That is absolutely not going to be the case this year. The Pennsylvania judges who are up for retention are absolutely going to face an onslaught of attacks. And they're limited in their ability to respond to some extent because as incumbent members of the court, they have greater restrictions on things that they can say, their fundraising is more limited, et cetera. But there's a growing level of engagement here. Last year, for example, 3 Democratic appointees on the Oklahoma Supreme Court faced a very organized and well-funded retention or opposition campaign that resulted in a very close defeat for one of them and very narrow margins of victory for the other 2. Historically, there's also been a low level of engagement in intermediate appellate court elections. There's none on the ballot this year. In Wisconsin, all 3 were re-elected unopposed, but typically low levels of engagement there. But this year in Pennsylvania, there will be, as I mentioned, open seats on the Superior and Commonwealth courts. And last year provides a good example of how far that can go. Texas had a number of elections for Court of Appeals, and Elon Musk's America PAC stepped in and spent substantially against all the Democrats running for re-election. And out of however many, I think close to 30 or 40 Court of Appeals elections, only one Democratic judge won in the entire state, which is quite dramatic. There's also a growing use of constitutional amendments and statutory measures to modify how judicial elections are taking place, as Louisiana voters are voting on just tomorrow. Last year, Arizona voted down a constitutional amendment that would have given judges basically life tenure during good behavior, which I'm told always exists. And Kansas seems poised to vote on a constitutional amendment next year that would change its elections from retention to partisan elections because the Kansas Supreme Court has a more moderate or liberal reputation. In terms of thinking about creating new courts and things like that, which Louisiana voters are doing tomorrow, this is also an increasingly common tactic. The Mississippi legislature, for example, created a new court, a new judicial system in the city of Jackson, which is a majority black city. Mississippi has long elected its judges, but this new district that has jurisdiction over a lot of cases in Jackson, unelected judges. And the Mississippi Supreme Court has upheld that as constitutional. Now, despite all of this going on, despite the fact that there's greater attention being drawn to all of this, there's also inexplicably some elections that are just not getting any attention at all. Despite the fact that by all measures, Georgia is a swing state, Georgia's Supreme Court elections have gotten very, very little engagement historically. I think that'll change whenever the court decides the constitutionality under the Georgia Constitution of the state's abortion ban, although it keeps not doing that one way or another, keeps kicking it down to the lower courts for a variety of reasons. But as courts sort of achieve this higher level of salience in the public's mind, then it seems as though we get this higher level of engagement. But there's still a lot of uncontested elections that feel kind of strange to some extent. It is strange to me that 3 members of the Wisconsin Court of Appeals were reelected this year unopposed, 2 of them being Scott Walker appointees. That is strange to me in a year when there's a lot of attention on the state judiciary. But inexplicably, candidates choose not to run. There are not always organized efforts to get people to run. And so even as we're seeing this higher level of engagement, if there's nobody to vote for, if there's no contested election, then, to some extent, this hasn't come to all states yet. But I think for a lot of reasons, most of which come down to the fact that state courts are increasingly deciding these high-profile issues that voters are able to appreciate the stakes of, it seems very likely that we'll increasingly be seeing stuff like this in many states throughout the country.
Wonderful. Thank you all so much. So this is your reminder to write down your question or submit it via the Q&A on Zoom. I did see some writing, so I have a question, but maybe before I even ask my question, I might give the panelists an opportunity to react if you were writing down something you'd like to say.
Well, all of us talked about money in one form or another, but I think the dark money in particular is a concern for me because it's not disclosed, the donors are not disclosed in the same way that PAC or Super PAC money is. And when disclosure happens, it's often after the election has taken place. So there isn't information for voters to use, whether or not they would hold that against the candidate or see that as an asset, knowing who was on what side. But it's all essentially behind the scenes, and when it is revealed, it's often too late to be useful. So rather than try to prevent money from being involved in Supreme Court elections, I think we want to think about ways in which to funnel the money in productive fashion, whether it's through political parties or PACs or something else that's accountable, or through the candidates' campaigns themselves. I think we probably have more to say about all of this, but that's one particular concern that's really been a new thing in Wisconsin these last couple of election cycles.
Michael or Quinn, anything to add before the first question?
One thing I'll say just sort of quickly is that though it certainly is the case that we're seeing greater attention now to judicial elections, there's a couple other points in sort of recent American history I think that are instructive in terms of thinking about times when elections were competitive. During the 1980s and 1990s, there was a growing level of involvement in judicial elections against justices who were perceived as soft on crime. There were a number of high-profile cases in which judges lost retention elections. In some states, those are the only instances in which judges have lost retention elections. And in the 1990s and 2000s, as some state Supreme Courts struck down tort reform measures on state constitutional grounds, there was also a growing level of engagement from corporate groups getting involved in some of these races too. And so a lot of those trends we can sort of see replicated in terms of allegations of being tough enough or not tough enough on crime.
Thank you. Okay, there's still questions coming in, so I'm going to ask one while I sort through what you all are asking. And this is a question with multiple parts. I'm not teaching a class, so this is permitted. So you can answer any aspect of this question that you find interesting. But the broad umbrella theme for the question is voter information. So one question is, what do we know about what voters know about state Supreme Court candidates? Does it depend on a variable that several of you mentioned, which is whether the race is designated partisan or nonpartisan? Does that affect sort of voter information? How does advertising factor into what voters know about candidates? If advertising alone is not educational enough, are there ways that you envision either state or local governments or other institutions serving a more educational role in a sort of, civic educational sense about state court elections and the candidates and their views? And then finally, the sort of the deepest part of this question, what kind of information should voters know before they cast a ballot for an elected judge who is, we alluded to, is in some ways a different kind of public figure or elected official than, say, a legislator or governor? So happy to start with whoever wants to begin that very multi-part question.
A lot of parts, we probably all have to say something about it. You want to start, Quinn?
Sure. I think about the question, sort of what should voters know in the context of sort of the elections in which I voted in. I grew up in Florida. I voted in Florida in my first elections, and there we have open elections for local trial courts that are formally nonpartisan and functionally nonpartisan too. And even as somebody who was following politics and following the law, I frequently had zero idea who to vote for. I had to rely on other kinds of proxies to some extent, who people were endorsed by, how people had registered to vote, which in Florida is entirely public information. And that's okay, I guess, but I don't know how to balance that against qualifications and things like that, because some of it comes down to what kind of judge do you want? I'm more inclined personally to vote for public defenders than prosecutors. But is that the ultimate criteria that we ought to consider in that respect? It's challenging, and I think it's easy for voters to both drop off and not vote, or to rely on cues that are more problematic, like perception of a candidate's race, for example, or perceptions of a candidate's gender, based on a name. And we have a lot of studies showing that voters do that exact thing a lot of the time, which is incredibly problematic. I think to some extent, I hate partisan elections, but they're also the most honest, because the stakes are the clearest. Voters know exactly what they're getting in some form or another. And my understanding of the literature in this space is voters ultimately revert to that anyway. Voters ultimately get the information about what the candidates think, but not as much with partisan cues formally on the ballot. I don't know. There's no good way to do judicial elections, I don't think. A lot of wrong ways.
So I think I am both a political scientist and a lawyer, so I'm kind of in between these two worlds. And I think those two worlds tend to see judicial elections kind of differently. The political scientists, I think, tend to like parties, and they like partisan cues and the information that parties give to voters. So they're much more sanguine about partisan judicial elections, partly for the reasons that were just stated, that partisan cues tell you something about the judicial candidates and what they stand for and how they're going to decide these cases. They also mean that the judicial races are going to look a lot more like the other races on the ballot, like legislative and executive races. Political scientists are okay with that. They think that's okay. It rationalizes the politics. And they also, political scientists, tend to think that judges are policymakers. They're not doing some sort of arcane magic that leads to kind of better law. Instead, they're acting on preferences about how government should make certain decisions and allocate resources, and they're not different from other types of politicians. If you talk to lawyers, and particularly if you talk to judges, they have a very different view. That law sort of dictates outcomes much more closely than political scientists think that they do, that there are right answers in law and wrong ones. Everything is not policy making kind of discretion, and law and judges are more constrained. And I think, particularly if you talk to judges, and I go to plenty of conferences where there's judges who will always have a story. They're often former judges who have been beaten by someone who raised a lot of money, or some ideological group has targeted them. So they're very unhappy with judicial elections kind of generally. And what's interesting is there is a kind of phasing out of a generation of judges that came in with a kind of different understanding about what the job was and how you got that job, and a new generation of judges that are much more comfortable with elections. And I'm curious what the world will look like in 15 years when judges have a very different view about how to get the job and how the job works. But at least the existing set of judges, and particularly the former judges, they have much more of a kind of judicial integrity model. That is, judges get elected because they're good lawyers and they're faithful to the law and they do a good job. And as long as they don't do a bad job or are affected by scandal. I think one of the judges we interviewed in our book said basically the way elections worked in Iowa, which is where she was a state Supreme Court justice, they were like, you would be kicked out of office if you were like a drunk or there was some sort of scandal, but otherwise you keep your job. And that's kind of how they think about it. That as long as you do your job kind of faithfully, that's what the job is about. And elections are just to kind of weed out the people who don't belong on the bench. And it's not about picking the judge that's kind of closest to you in terms of policy preferences. It's not like other offices. And those are kind of two different visions of the way politics work. There's no question partisan elections provide more information to judges. And I think that voters in partisan elections tend to be better informed about what the stakes are and what the candidates think. There's a lot of evidence, for instance, in nonpartisan elections that inflammatory ads have a bigger impact because that's the information they have. And so they rely on that rather than a partisan cue. We at one point found that money played a much bigger role in partisan election systems than nonpartisan. But if there's still a gap, we haven't really redone that sort of analysis, but if there's a gap, it's much smaller now. Because as you know, in states with nonpartisan elections, it's often pretty partisan, and everyone knows kind of where things stand. So I'm not sure in terms of the role of money that there's as big a difference as there once was. The data we looked at was from the 90s. This was a study a while back. But in terms of what the voters know about the candidates, I think there really is a difference between partisan and nonpartisan elections. Wisconsin might be a weird exception, or like Michigan might be an exception where even if you're nonpartisan, everyone kind of knows because there's so much money spent and the candidates are so well identified. But there's lots of states where the candidates are less known than they are here, and the stakes are lower, and it's very easy for candidates to fall under the radar. As long as there's a D or an R by a candidate's name, you as a voter know a lot of what you need to know, even if it's a very down ballot, low information affair. And that's sort of the trade-off that you have to think about as a polity when you make judicial elections partisan or nonpartisan. Because when the nonpartisan races, it really is true, we don't know a lot about those candidates in most instances.
So we got some evidence this week on what voters know about judicial candidates because the first Marquette Law poll asking about Brad Schimmel and Susan Crawford was released on Wednesday. About a third of respondents could say one way or the other if they had a favorable or unfavorable opinion of Crawford. So 2/3 couldn't even render a kind of thumbs up, thumbs down on whether they thought she was basically a good or bad thing. For Brad Schimmel, the familiarity was higher. It was about half of respondents could give an answer saying they were favorable or unfavorable. He is a former state attorney general, has won statewide elections, so ought to be a more familiar figure at this point. But we're weeks into this election with probably tens of millions having been spent already, and still a majority of the electorate can't evaluate the candidates. The Marquette poll decided not to actually ask people how they would vote because it wouldn't be very informative about what's going to happen on April 1st. So I think one of the things that strikes me about at least the schedule in Wisconsin is how quickly the public ramps up its awareness of the candidates. They go from unknown figures 2 or 3 months before the election. We've just come off the November election, so there's a little bit of a hangover from that. After the new year, people begin to pay attention, and within a month, the electorate goes from not knowing who these people are to them becoming household names. Janet Protasewicz's name wasn't pronounceable to most Wisconsinites because they were unfamiliar with her, and now everyone is aware who she is. The race here has been covered in the national media. It's been in the New York Times and Politico and national TV news and elsewhere, and yet there's still pretty low familiarity. The way that people have become informed is mostly through advertisements. And that's unfortunate because the ads are not well matched to the criteria that are probably valuable for making a good justice. As Miriam mentioned, many of the ads are about crime, records on criminal justice, toughness on crime, associations with police or law enforcement, not very indicative of the kinds of things they'll actually address on the court. We're providing voters with a lot of information about things that maybe aren't most useful for them in figuring out who the right candidate would be. One of the things I think ads do that is helpful is showing the allegiances of the candidates to groups and causes, things they've been entangled up in the past or have a connection to. That's indicative of their probably judicial philosophy and how they think about cases. And I think that is worth doing, and often it's done in a negative way to point out associations of one's opponent, but I think that's useful. What the ads and even the media are not doing is talking about which of the candidates is smart enough to do the job and has the reputation in the legal community to be trusted, is collegial. This has been a real problem on our Supreme Court of collegiality among justices who seem not to like one another or cooperate much. Some cases even devolving into physical altercations or insults back and forth. So I think asking a justice or a potential justice how they will work with the other 6 people on the bench with them would be a really valuable question, but that's not something that arises in ads. Maybe it will show up in a debate. One last thing about partisan elections. They've essentially become partisan in Wisconsin, and Michael's right that partisan elections have higher turnout. So if we were to put a DNR on the ballot next to the candidates, we would probably even beat the 40% turnout from the 2023 election. So, this is what we get when elections are officially nonpartisan. But I don't know if I would characterize it as voters knowing more when it's partisan. I think it's easier for them to find a candidate that probably aligns with their views, but it might actually override other information, some of which is useful about the backgrounds of candidates, some of which is problematic, like gender, race, age, other kinds of things. So it's a mixed bag. I think, as you said, there's not a good way to do this.
Yeah, I think with respect to sort of what it might override, I mean, because somebody simply, being conservative or liberal in most instances doesn't tell you how they're going to rule in all instances. People have different streaks in different places that are going to push them to different decisions. So yeah, it definitely does override something, but I don't know, and I don't know how useful the messaging that candidates actually put out when partisan elections actually are. But then not really talking about the issues either doesn't really help give voters much knowledge. I think the one thing that I guess I wonder how much voters embrace or not is this idea that judges are not policymakers. How could we say that they are? When I think voters are increasingly skeptical of the Supreme Court. And I think that voters are probably recognizing the thing that, I don't know, deep in our bones we probably know, which is that judges are policymakers. They don't want to call themselves that. The idea that once you put their robe on, oh my gosh, all of it goes away. But that can't be true. And I think voters are sort of aware of that as sort of a realistic matter too, to some extent.
There's a judge that we interview, Bridget McCormick, who is Chief Justice in Michigan. And it was really interesting to talk to her about campaigning. Because obviously running for judge is different than running for governor. Probably most notably, you can't say how you would decide cases. And so she would say, when she talks to voters, they ask her how she would decide things, and she says, well, I can't really tell you, but you should vote for me because I'll do a good job. It's very nonspecific. It's not like the way that you'd run for president, and the voters would want to know exactly where you stand on the issues that are most important to them. So in some ways, party is a useful tool in being a proxy for that, given that they can't say exactly what they would do on issues. There's ways in which they can signal kind of what they would do, and I think that's been an issue here in Wisconsin, where lawyers have argued exactly what you can and can't do. But it's much more complicated for judicial candidates than for other types of offices.
That's a nice segue to our first group of audience questions, which is about ethics and the interaction of ethics and judicial elections. I'm going to try to group some of them together, but one question has to do with judges who decide cases involving their donors, something that was mentioned before. Is that ethical? Is it legal? What are the limits? Michael alluded to a U.S. Supreme Court case on that, so maybe we can turn to that a little bit. And then another dimension of the ethical questions that I received have to do more with candidates actually doing what Michael just said, at least Chief Justice McCormick did not do, which is candidates who state their views. There is First Amendment protection for judicial campaign speech, and it allows judges to describe at least their views and their values, although not a commitment to decide cases in a particular way. But what ethical concerns might that raise, or does it? So I think that's the nature of these questions for anyone to comment on.
Yeah, I'm happy to talk about the case I mentioned, Caperton versus Massey, because it's a really interesting case. It's a due process case that probably many people in the room are familiar with. But the facts are pretty simple, which are that Don Blankenship, who's CEO of Massey Coal Company, they had, I think it was like a $50 million jury verdict against the company. And what he realized was that this current Supreme Court, as it was constituted at the time, probably wasn't going to decide his appeal of that jury verdict the way he wanted, that they would probably let it stand. And so he also realized it wasn't going to be that hard potentially to flip the West Virginia Supreme Court to his side. So he spent, I think, what was at the time a kind of unprecedented amount of money, about $3 million, which is not a lot, right, by Wisconsin standards, but $3 million on a 2004, I think, West Virginia Supreme Court race. And took out a longtime incumbent, replaced him with a very young kind of Republican lawyer who he had been connected to through some like Republican activists, and flipped the kind of partisan control effectively of the West Virginia Supreme Court. And the candidate that he managed to get elected, Brent Benjamin, went on to preside over, because of a bunch of recusals, preside over the appeal of the jury verdict, which went his way. And they reversed the jury verdict and saved Massey Coal Company at the time something like $70 million after interest and stuff. The case had kind of dragged out for very complicated West Virginia kind of reasons. And so this was appealed by the plaintiff. And who said it doesn't seem fair that Don Blankenship spends $3 million, changes the West Virginia Supreme Court, and then gets to save $70 million because of all of that. And shockingly, the U.S. Supreme Court agreed and found that under these circumstances that violated due process for Brent Benjamin to participate in that case. So one take on that was that's great, because now the Supreme Court has created due process law, and this is not expected at all, that would require recusal, as it did in that case, where you have a judge elected on the strength of a lot of money from someone who's basically a litigant. I think that's the right answer, and it should be the right answer in lots of cases. But it turns out that decision really had very little impact on the law. So when we looked at kind of what state bar ethics codes, how they responded to that, and how judges in different states had responded to that, they often added language that said something like they ought to consider campaign finance considerations. But as far as we can tell, it hasn't really changed judicial behavior very much. It hasn't changed the professional codes very much, or kind of the way that judges do their job. It might occasionally do that, and it should, but we don't think it's had a huge impact. One would think that judges would feel a greater responsibility to recuse as just the magnitude of money goes up. It's a little hard. Generally speaking, judges decide for themselves when they recuse. That's reviewable. But it's also other judges who will review that. And so this is largely kind of self-policing by judges who often think that they're acting kind of responsibly. And you've seen this in the U.S. Supreme Court. When I was on the U.S. Supreme Court Commission, this was one thing that I came away, I learned a lot, and I became convinced that the U.S. Supreme Court really does need an ethics code with some teeth and some rules about recusal, because that is left completely to them at the U.S. Supreme Court level, and it's non-reviewable. It's essentially their decisions. And given what we've learned about the kind of finances and relationships that the justices have, I think it basically requires some response, and a lot more than what the U.S. Supreme Court has done. They sort of announced some standards, but I don't think anyone thinks it really changes what the justices will do. So I do think that this is an area we should think about, but at least as the law as it stands, and where the guidance stands, it seems like it really hasn't changed with the way that judicial campaign finance has changed over the last 20 years, at least in my view.
Sometimes when I teach, especially con law, I find myself wondering out loud, like, I wonder if this is still good law. And I don't think that Caperton is, unfortunately, insofar as the majority that decided it doesn't exist, and the dissent that dissented is functionally the majority now. And so I think it's the right answer, but I don't doubt that the court would overrule it if it had the opportunity to. I think the problem is two-sided in some ways. There's chronic under-enforcement of actual judicial ethical problems at both the state and federal level. On the other hand, the process can be too easily politicized, such that entirely fake or fraudulent allegations of misconduct can rise to a level just with a complaint. And I think that there's a good example of that in Wisconsin, where Justice Protasiewicz was on the verge of being impeached for something. We'll figure it out. But, and in North Carolina last year, there was, when Justice Allison Riggs was running for re-election, there was a complaint that was filed against her on entirely nonsense grounds just to be able to say in an ad that a complaint had been filed against her. And that's problematic for a number of reasons. On the other hand, and though I don't think that, in my read of the relevant rules, I don't think Justice Protasewicz did anything wrong as a candidate, it is kind of silly at the same time that the way that she had to talk about gerrymandering was to say, my value is that the maps are rigged. That's just a weird way to put those words together. It doesn't make sense as a sentence. And I think that that's sort of a surface level problem in one way. But the deeper problem is that there's a lot of unethical decisions that are being made. It's deeply unethical for judges to decide cases involving their donors, regardless of what the level is to a certain point. And maybe the answer is different in smaller jurisdictions where everybody knows everybody, but I'm not so sure in actuality. I don't walk away from a conversation like this without a very firm conclusion that the Supreme Court's holdings with respect to what the First Amendment requires doesn't just damage judicial integrity in many ways. Because no, I don't think that we should have private campaign contributions in this space. I think public funding is the only real answer for something like this. But that, an end to private contributions, would clearly manifestly be unconstitutional under the First Amendment. And it's this unusual space where the court has allowed some restrictions. Like in Florida, judges are prohibited from personally asking for money, and that's barely constitutional. But that's such a minimal thing at the end of the day. They could have the conversation with somebody and just pass the phone on to somebody else as like the formal ask. That does nothing in practice other than create some artifice of separation. But we also do need to be very seriously concerned about the weaponization of this at the same time, because if a process results in somebody getting removed or impeached and removed by a legislature, that's unreviewable functionally, and that's deeply problematic for a separate reason. So problems with extremes on both sides, I think.
Quick thing, just to make the distinction again between PAC money, which is regulated and transparent, and 501c dark money, which is mostly not. Both of them are problematic. There are ethical problems all over the place, potential conflicts of interest. But at least with the PAC donations or the direct contributions to candidates, the public gets some awareness of those things. If the candidates are not term limited out, there's a chance for voters to take action if they think something inappropriate was done in the next election. With dark money, the public may never know who the backers were, depending on how it may be funneled through a couple of groups to get to the point where it's actually spent on behalf of a candidate. So the public, maybe the justices, don't even know where the money has come from. So we should at least have transparency, but I agree that the whole system is just fraught with potential ethical problems.
Thank you all. The next batch of questions that I received, I think build on something that Michael talked about, which is possible alternative structures for judicial selection. So one question asks about appointment methods. Actually, a couple questions ask about this. Like, we're sort of identifying a number of pathologies or problems with judicial elections. Are there problems with systems where judges are appointed? And if so, like, how would you sort of compare those? And then, to the extent that there is a benefit between either partisan elections or nonpartisan elections, and between original elections and retention elections, if you could design some configuration, taking all of that into consideration, what would you go with?
I'll start with talking about appointment systems to some extent, which have their own problems in a very different way. One of them is that, a number of states use this idea of ostensibly nonpartisan merit-based selection, which has some neutral evaluation of candidate qualifications that are then presented on a slate to usually the governor for selection, which sounds amazing. But there's enough opportunities for partisan machinations to sort of step in here that in many states, there's sort of been partisan capture of these processes. In a couple of states, there's been modifications to the identity of who is on the commission, such that the governor has greater power to have their own appointees on that system, which takes away some of the neutrality of the system. Even when a system mandates that there be state bar representation, Florida is a great example of how the governors have routinely bullied the Florida bar into modifying who sits on these nominating commissions. Florida is also a good example of how you have a dead hand problem, where regardless of whether Ron DeSantis or Andrew Gillum was elected governor of Florida in 2018, they would have had 3 judicial vacancies on the Florida Supreme Court to fill, and they would have been stuck with the same nominating commission that had existed for some time. To some extent, that's good, but it meant that voters could not do anything that election to decide the control of the court, even though they were voting for a governor who'd make nominations. And another thing that can happen that's deeply problematic for another reason is in states where you do have these commissions where there's Democratic representation and Republican representation and nonpartisan representation, sometimes you just have the governors just refuse to appoint members of the opposite party. The governor of Arizona left a number of Democratic seats on the commission vacant for some time. My response to that is you sue him at that point and force him to make that nomination. It's not a responsibility. I wouldn't describe it as a ministerial responsibility totally, but it's not something that the governor can just say, no thanks. And so we have problems on that side too, because obviously governors value these nominations. They can use them for a lot of different purposes, and the more just sort of unadulterated control that we give to partisan officials, the more that we get away from these systems at the end of the day. As to designing an ideal system, pass.
So I think when we started thinking about judicial elections, I think there was a lot of support for appointment models that were more like the federal system. That's, I think, what most lawyers kind of think would be better than judicial elections. And I think there's those appointment systems are a lot less popular today than they used to be. And certainly, like on the commission, what we heard from a lot of experts and activists was that the federal appointment system has huge amounts of problems. And that people don't like that either. And I think if you look at the history of judicial selection, we started out with appointment in the early 19th century. We actually moved to elections to make these less political because judicial appointments were kind of patronage positions, they were hacks. And the idea was to free judges from the kind of political control of politicians. Those elections became controlled by politicians nonetheless, and so there was a move toward nonpartisan elections and then ultimately toward merit selection. And it seems like every move gets captured by the politics, and so it is this kind of whack-a-mole game where there's a lot of incentive for the politics to capture judicial appointments, especially as judgeships become more important and consequential. So I don't think there's any one reform that solves all the problems, and certainly what we see in the federal kind of appointment and confirmation process is pretty political. We're seeing a lot of money spent now in the campaigning for confirmation of those appointments, tons of lobbying for those judgeships. What we understood on the commission was that lifetime appointment maybe not the greatest thing. Maybe it's not great for judges to be on for life. The Supreme Court justices are serving longer and longer terms. They're staying on the court longer. There's lots of reasons for that. Lifespans are increasing, but also those positions are more valuable. The court is more powerful, and what that means is they want to hang on longer, and because those appointments are so valuable, they are timing their retirement strategically. So you're seeing Court of Appeals judges and Supreme Court justices, it seems, trying to time their retirement for the right president, right? And you saw that with Kennedy, you sort of saw that with Breyer, and that's not great. And also having a judge on the bench for so many decades might not be great. There's some evidence of drift from where they initially start out. They sort of lose touch with the politics under which they were appointed, and all of those things are things that we should worry about with appointment systems. Now, appointment systems have some advantages vis-a-vis judicial elections, but I don't think it's a clean choice. One is so much better than the other. It's definitely true, I think, reform types prefer merit selection over just kind of the straight competitive elections where you end up with retention elections. But again, the politics can kind of capture that too, just as Quinn sort of described. So I think there's lots of kind of value choices you have to weigh, but not an obvious answer that one system is better than the other. We kind of come to this compromise in the book that you can keep judicial elections. They're popular. You know, the states that are considering merit selection have kind of already shifted over to merit selection. So it's not really a live issue in many states. But one modest thing you can do is you can have the judicial elections, but just get rid of re-election, have one single term, where the judges don't get so old. You have like this periodic opportunity for these seats to come open, and no one stays in for too long, but long enough that the judges accrue some experience and seniority, and those can be good things in moderation.
Well, this is messy. I think there are a few levels of reform we can think about. One would be to get rid of elections altogether, and so to choose justices in some other way. And you might say, well, let's just adopt the federal model where the executive in the state, the governor makes a nomination, and the state senate would approve. There can be foot dragging, you might imagine, in a Senate that would not want to approve a nominee of a governor of a different party. In Wisconsin, we've had a lot of battles over appointments to commissions and boards and other things, so that would easily extend to the court. You can imagine there being open seats on the court for years, potentially, depending on the makeup of government. So maybe there could be an enforcement mechanism that requires the Senate to act in a period of time. There could be a supermajority requirement, so one party can't simply stack a court very quickly if it were in control of government. So those would be non-election solutions. Given what we have in Wisconsin, I think there's some tweaks that could be helpful. These would be sort of small improvements. I think very helpful, but within the system we have. Restoring public funding, I think, would be very helpful to take justices out of the business of having to spend months on the campaign trail raising money. That's one. Term limit, maybe we have a 10-year terms on the court here, so limiting justices to one term is a possibility so that you never have a sitting incumbent who has to raise money and think about the interest of the parties who are in front of them. The trouble with that, however, is that there's always going to be an open seat, and open seats tend to attract the most money, as we're watching this year with the open seat on the state Supreme Court. So there is that trade-off, and maybe good jurists would not find it worth their time to campaign for just a 10-year gig. And so I think at one point in the past, there was a commission proposal to extend the term length to something like 17 years and make it a one term. So it's sort of a capstone in your career. You could run for the Supreme Court when you're in your 50s, retire in your 60s, and that would be the end of it. That's an interesting possibility. If I had a magic wand and the First Amendment was not a barrier, dark money would be gone. We'll just put the money in a transparent place so we can all see it. That would be number one. And I would prohibit sitting justices from actually campaigning for and against either their colleagues or people who are running to be their colleagues.
Thank you all. Okay, this is the CLE moment. I have remembered the passcode for today's event, if you are attending virtually and wish to receive CLA credit, is April. That is next month. When the election takes place. APRIL is how you spell April, the month. I will say it one more time. The passcode is April. I will also say it again at the end. Okay, we have time, I believe, for one more question. And this is sort of surfaced in some of the questions that folks asked, and maybe also a natural extension of some of the comments that were just made. So the question I want to ask is sort of a from here to there question. I'm not sure I've captured every single possible reform that you all have mentioned, but there are a number of them, including possible types of campaign finance reform, like public financing, different forms of disclosure, limits on from whom and when candidates might be able to raise money. There's possible reforms that you all just discussed to the structure of judicial selection, including whether candidates only serve one term, various forms of ethics reform. So how, if you wanted to, if you were a person, not you personally, but if you were someone who wanted to advance that conversation, what would be the right way to do that? One question asked about the role of bar associations. I think you could ask a similar question about the role of civic associations, nonprofit groups, others. Michael, you served on a high-profile Supreme Court study commission. So should there be such a commission for states? If so, would it be collectively or individually? How would you recommend to someone that they keep these questions and these ideas in a kind of public dialogue for meaningful consideration? And I'll just add one more question. If you had from all of these reforms, if you were like, okay, in study commission, if you discuss nothing else, please consider this issue. Is there one that, from today's discussion, that you would pick to make sure was on the agenda? Not necessarily to pick the outcome of the discussion, but to make sure that it got attention.
One thing, I guess, is I think staying knowledgeable and being aware of sort of what is going on is such an important part of this. Knowing who's running for what, when different elections are up is so important because it can be easy to miss things. And for an election to happen entirely uncontested that you're not even aware of, I think it's not a sin of the voters, it's a sin of the system, but it's something that ultimately affects everyone. So I think being aware of it is really important. And I think it's also a matter of, as is an evergreen sentiment right now, like call people who represent you and articulate what, not necessarily what you want to happen, but that you want this conversation to take place. Because I think that is probably the only option in a state like Wisconsin where there's no initiated constitutional amendments or something like that. If you live in a state with an initiated constitutional amendment, by all means, do the whole grassroots thing and just, magically make it happen without any external funding or whatever. But I think that part of it is thinking about how we are engaging in these systems as a huge part of it.
So I think my experience on the U.S. Supreme Court Commission was very interesting, and I think it was a good exercise. I think we were under no illusions about why the president created the commission, which was largely to make the problem go away. We understood that. We weren't told that explicitly, but it was implicit. Basically, there was a lot of pressure from the left to increase the size of the court, and I don't think the president was interested in doing that for lots of different reasons. And by creating kind of a blue ribbon commission, it makes the problem kind of go away for a little while, and hopefully people forget. And when they come back, you've got a nice report. You should read the report. It's a very good report. And I came away thinking there was some value in that exercise, in that I learned a lot, even as someone who's thought about these issues. It was interesting to talk to people. There was ideological representation on the commission to kind of understand what the limitations were. And the conclusion that I came to, and I think a lot of commissioners did, was that at least for the U.S. Supreme Court, which is not what we're talking about, but was instructive, was that the things that would make a difference would be very hard to legislate or impossible to legislate. And the things that were feasible probably wouldn't make much of a difference. So it was pretty clear kind of what the possibilities were after that. It also redirected me to think more about kind of ethics reform and problems that I hadn't thought very much about, but the exercise encouraged me to do that, and I learned a lot. I think there's some value about doing that at the state level, and I think that's the kind of process that a state would probably want to go through in thinking through these reforms, because it's a really complex choice to decide to go to an appointment system or an election system or a merit selection or some other permutation. And really, we can think about, partisanship or the campaign finance part of things or how informed voters are, but those don't all kind of move in the same direction. Like as we said, a partisan system, voters may be more informed, but there may be more money. And so you have to figure out what's more important to you, because you can't have it all. And a polity has to sort of decide what the value trade-offs are. If I think about judicial elections as they're practiced, I think my primary concern is money. It's campaign finance. And really, that's not specific to judicial elections. It might be worse for various reasons in judicial elections. But I think generally what we see in American politics, we have hyper-partisanship, but the way that's expressed, the kind of ammunition in the partisan game is money. And donors are very partisan and they're very ideological. And that pushes the parties in ideological, more partisan directions. That's not the whole story, but it's a really important part of the story. The limitation is, as Barry suggested, the Roberts Court has been very restrictive when it comes to campaign finance regulation. In most of my life, I'm an election law person as much as a judge's person. And the story is pretty unrelenting from the Roberts Court, which is you can't regulate campaign finance, that it is very protected under the way that the Roberts Court thinks about this. And so we've seen a real transformation in campaign finance law that I think makes it very hard to regulate campaign finance in a really meaningful way. And disclosure used to be something that was more permissible, but even that's being choked off by the court. And I think we'll see real restrictions come down the road in the next decade on disclosure too. So I'm not that hopeful for campaign finance. I think where the reform energy on campaign finance is going is really public financing. That's leveling up rather than leveling down, instead of restrictions, subsidies. And that's where the Roberts Court seems the most hospitable for lots of reasons. But even there, the Roberts Court is not a really big fan of public financing. There's a big Arizona case that I think puts real limitations on how public financing is structured. So one problem here is we've got a Supreme Court, that doesn't like the regulation of politics. So if you don't like the way politics work right now, it's very hard to change it through regulation. Because the court sees a lot of First Amendment problems with any kind of really meaningful regulation. So we get back to the problem that I started with, which is the things that would really make a difference, very hard to do, and the things that we can do probably don't make a huge difference.
1 minute on from here to there. In states that allow voters to put things on the ballot, there's a possibility for reform there. I think direct democracy has a mixed record in terms of making good policy. But when it comes to election reform, we have seen in places like Michigan, redistricting reform was put on the ballot by a citizens group, really a grassroots movement. The state now has a nonpartisan or tripartisan system for drawing districts that are much fairer, so there are models for getting good election reforms that way. I think in states like Wisconsin, it's probably going to take something like a bipartisan blue ribbon commission that truly has partisans from both sides on the commission. I'm not hopeful that that would work, but I think it's the only path that exists. I think one reason it has some hope is that right now, neither party has a clear advantage in state Supreme Court elections. There was a run of a few years where Republicans seemed to win all of the Supreme Court elections, and so they would not have an incentive to make changes to that system. But now it's quite competitive. I don't know who has the upper hand this year, but I think both sides would see that it would not obviously favor one party or the other to make a change, so there might be a possibility there.
All right, thank you so much to our amazing panel and to all of you for being here. I have to say one more time that the passcode is April, but mostly we want to thank you for coming out. If you're here in person, there are refreshments in the room. We welcome you to stay around, especially because I apologize I did not get to every single question. But for now, we will see you next time, and thank you to all of you and to our panel.